50% of people do not have a will. We have been talking about this statistic a lot over the last month or so. Powerful, isn't it? Just think about it. 50% of us, when we pass away, we're basically saying to our loved ones, good luck. And we've got to change this. In fact, this month, and I'll talk a little bit more about this, I'm getting my will updated and complete with the help of the team at Crane and Woolley Law Firm, our partners here on the consumer team. Justin Crane from Crane and Woolley joins us tonight. And Justin, I want to welcome you back to the consumer team. Over the last month or so, we've learned that wills are important. You got to start with a will. I mean, that's starting the process. But as I've learned from you, and as I'm starting to really learn as we put my estate plan together, a trust is an important part of an estate plan too. In fact, for many people, the estate plan is not complete without a trust. So Justin, welcome. Not just a will, but an estate plan that includes a trust. Why is this important? Great to have you back.
Yeah, thank you. One thing that I always like to remind people or teach them for the first time about trusts is that there are a variety of reasons that you may want to use that as a legal tool. But one of the benefits everybody gets is if we do it properly, your trust does not need to be proved in court after you've passed away. And as a reminder, if you write a will, it doesn't have legal effect until you die, and we prove it or we probate it through that legal process in the courts. But other than, probate avoidance, I would say that everyone listening should think about all the people that are involved in your life, maybe even the ones sometimes that you didn't want to be involved in your life. In particular, if they're family or their children or they're maybe children in blended families, you also have to consider, do they get along with each other? And the reason I bring this up is when we talk about blended families, it is my belief that trusts are really the only option that makes sense, because if we had used a will and we went through the public proving or probate process, we are required to basically have a public invitation to everyone, let's say all of the kids, from both sides of the family, and say, do you want to show up to the hearings? Do you agree with everything that's been written down? And if we can't get them to actively state they agree with everything, and I do not disagree with anything, even that act of not agreeing can delay or cause problems in the process. Certainly, disagreeing is a contested probate. You can avoid all of that with trust planning, and that's probably important, especially if you have children that maybe they didn't even grow up together, that you do want to take care of, but you don't want to necessarily ask all of their opinions on if they get along with each other. A trust can be immediate at your death. The person you wanted in charge can immediately distribute assets. There isn't a court process, and you avoid basically asking everyone, do you agree, and do you want to be involved in this process? They'll just receive what you intended. I would also say that if you have multi-state property, you own a house in Texas, but you also own a house in, let's say, California. A lot of people get excited in Texas when I say California can't tell Texas what to do. But as a reminder, Texas can't tell California what to do, or any other state. And if the traditional process of saying that your property passes through a will has to go to court, and it does, I would just remind people that if you die with multi-state property, we're going to need a judge in Texas to sign off on the transfer of, say, your house to your beneficiaries in the probate process. And then it's called an ancillary probate, but we'd need the judge in that other state or states to also sign off on the property in those states. To me, that's another instance where why would you knowingly involve two different judges in courts when you could avoid that with something like a trust? Another big topic that I think it probably, unfortunately, hits home with a lot of us out there is divorce. And without spending an hour on how divorce would really work in legal terms, most people, when they receive assets from, say, a parent when they die, if they're happily married, those assets start paying for the house that both spouses have. It starts paying for the kids, food, dinners, vacations. It's commingled. And if later on they go and they get a divorce, it's almost impossible to determine what was inherited. And inheritances all the time get split up, between maybe your son and the ex-wife or your daughter and the ex-husband. There are ways with trust planning to protect that so that it is clearly always separate property, and that is a way of kind of protecting from divorce for your beneficiaries. And so I think it's important people know you can do that. And then, the biggest thing that I would leave everybody on is this, which is overall, no matter what your goals are, if you have someone who has special needs, you probably are already aware that you need to ensure that money doesn't get directly into their name, because they might lose public benefits, right, for having too many assets. And you can use a special type of trust to leave assets to supplement their benefits. They won't get disqualified from their benefits, but what you've left will help them. But one thing that I would mention for everyone listening is you actually don't know for sure if you might name your son as a beneficiary. And what if you got in a bad car accident and your son was with you and you die and your son ends up living but is disabled? You could use a trust to even say if someone that I didn't know was disabled becomes disabled, that they would be protected and could get their government benefits, the supplemental programs for their needs, and the assets that you left without causing problems. So it's a sort of a mouthful and a lot of things to consider, but there are so many reasons that the trust should at least be a discussion when you're considering your estate planning needs.
Justin Crane from the Crane and Woolley Estate Planning Law Firm, and a couple of really good special offers for Consumer Team listeners tonight. First, get a free initial consultation at Crane and Woolley when you mention Consumer Team. Secondly, and this will be for a limited time because this is an extraordinary offer, mention Consumer Team and you'll receive a 25% discount on proactive planning services at Crane and Woolley, 25% off for a limited time. And let me tell you, it feels really good to be getting this aspect of my life buttoned up. So let's get this done. Here's the phone number, Crane and Woolley, 972-560-6288. 972-560-6288. The website, cranewooley.law. That's cranewooley.law. Coming up tonight on the